Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about class actions and administrative law. Cases that should have gone to the Supreme Court of Canada, but didn't. Bradley Dorman was involved in a potential class action proceeding against an automobile insurer. Essentially, what he was trying to do was sue the insurer, even though there was also an administrative scheme set up in his province to deal with litigation against insurance companies. And he argued that the litigation against insurance companies that was done through the administrative scheme didn't contemplate class actions, so his case was entitled to go to court even though there was an alternative remedy available for him under the administrative sphere. And this case raises important issues that the Supreme Court of Canada missed the opportunity to determine. Specifically, the case related to the question of whether or not, if there's an administrative remedy, you can also go to court and seek a remedy there. The problem that arises in these types of cases is that governments can essentially enact administrative spheres to deal with anything. They can create administrative tribunals, as we've seen in British Columbia, to deal with personal injury cases. They can create administrative tribunals, as was almost done in Alberta, to deal with traffic tickets, where people might face penal consequences as a result of the conviction for that dealt with through an administrative body. By creating administrative mechanisms, the government essentially gets to sidestep much of the law that has dealt with charter rights, has dealt with certain disclosure obligations, and they can constrain proceedings in a way that they can't do by having a proceeding in court. Mr. Dorman argued, and I think quite reasonably, that by doing the proceeding in the court, he was relying on the inherent jurisdiction of the court. But it seems like courts have continually rejected the idea that the inherent jurisdiction of the court can apply even where there's an administrative mechanism to obtain a financial result or a result dealing with whatever it is you want to challenge in court. And that can't be the case, because essentially that allows governments to oust the inherent jurisdiction of the court by just calling something administrative law. The overuse of administrative law is something the Supreme Court of Canada should already be ahead of, and yet it seems to me that they are behind the times in considering the way that administrative tribunals are significantly limiting the rights and access to the courts that Canadians are supposed to have and that are guaranteed under the Charter. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.